Welcome, everybody. A big welcome from IWRA to this webinar titled The Human Right to Water and Its Implications for Law of Transboundary Aquifers. Really excited that you guys can join us today. We have lots of attendees attending from all over. And just so you know, if you're new to IWRA and exploring the organization, we are an international network of researchers and practitioners who work on a multidisciplinary range of water resources issues. IWRA provides a global knowledge-based forum for bridging disciplines and geographies by connecting professionals, students, individuals, corporations, and institutions who are concerned with the sustainable use of our world's water. For today's discussion, our panelists include Dr. Gabriel Eckstein, who's the professor of law and director of energy and environmental and natural resources systems law program at Texas A&M University. Amael Notini, who is a legislative analyst at the Brazilian Federal Senate, serving as the Brazilian Legislative Institute. This webinar will debate the potential implications that the human right to water may have in the applications of law on transboundary aquifers. Today's webinar will begin by a presentation by Amel, followed by comments from Gabriel Eckstein. The two presenters will engage in a dialogue, and then at the end, there will be time for your questions and answers. So please make sure you put your questions in the Q&A box next to the chat. With that in mind, I'd like to turn the floor over to our moderator for today's discussion, Dr. Imad Antoine Ibrahim, Assistant Professor in Environmental Law and Governance at the University of Twente in the Netherlands. Imad, over to you.
Thank you very much, Lindsay. Today's topic is extremely important and extremely relevant for international community, also for national and local stakeholders. If one wants to start to discuss this from historical perspective, the issue of groundwater itself did not receive a lot of attention previously, until the last 20 years or so, where further and more attention is given to it at the legal and policy level from legislators and policymakers alike. So and then we add for that the layer of transboundary governance, which further complicates things. Now, this is what's taking place and happening. In the same time, the international community was trying to adopt and having efforts over the years to adopt finally a human right to water and sanitation in 2010, which is considered a big success. Within this success, one has to mention that the international community was able to adopt before that in 2008 another instrument, which is called the International Law of Transboundary Aquifers, the draft articles on the Law of Transboundary Aquifers. That is before the adoption of the human right to water and sanitation. These things were happening separately, and scholars did not pay much attention to them until recently, where studies, publications, and books are starting to understand what could be the interplay between the human right to water and sanitation and groundwater in general, but more specifically transboundary aquifers. And the focus on aquifers or groundwater, it's because of its high quality as a drinking water source for everyone, and as 2/3 of existing fresh water worldwide is groundwater. Given all of this and taking into account all the factors into consideration, this webinar seeks to pave the road a bit and further clarify this issue. What is the connection between the human right to water and transboundary aquifers? For that, I'll give the floor to Amael Notini to start and explain to us how do we move from there? Where do we go with this topic? Amael, the floor is yours.
Thank you, Imad. I would also like to thank IWRA for the opportunity to discuss such an interesting topic. I'm going to share my screen. Okay. So to start, I should stress that I'm speaking in my personal capacity, and the views expressed may not represent those of the institutions I'm affiliated with. So To address the issue of the human rights of water and its implications for the law of transboundary aquifers, I thought it should be interesting to first introduce the law of transboundary aquifers, then introduce the human rights of water, and finally discuss a proposal of conciliation of these two legal regimes. To start with the law of transboundary aquifers. We should see that there are two legal regimes that apply to transboundary groundwater. The first one applies majorly to transboundary surface waters, but applies also to connected groundwaters. So it protects groundwaters only to the extent that it's connected to transboundary surface waters. And also the law of transboundary aquifers that Imad mentioned, the draft articles adopted by the ILC, that addresses groundwater in a more broad scope. It addresses both confined and unconfined transboundary aquifers. But there are some legal differences between these regimes, mainly in their scope, as I stressed, but also in their position in international law. The law of international watercourses is more established in international law than the law of transboundary aquifers. We have a multilateral convention that many scholars believe to reflect customary international law, as well as multiple bilateral and regional treaties. Whilst in the law of transboundary aquifers, we do have a draft article that was the result of the works of the ILC to codify this legal regime, but it is still in an uncertain territory in international law. There are some that believe that it reflects customary law, and others that think that it has still not reached that state in international law. So we have a more restrictive scope in international watercourses that applies to some groundwater that is more established, and a more broad legal regime applicable to groundwater, but that it's still under development under international law. And these two legal regimes prescribe a series of obligations that, and the main ones are the principles of equitable and reasonable use, the prohibition of transboundary harm, and the principle of cooperation. Since we're dealing with the right to water, I thought it would be best, due to our restrictions of time, to focus on the equitable and reasonable use as it addresses the allocation of water in considering the interests of the states involved in a transboundary water resource. So we'll discuss how this allocation of water is related to the human rights of water and how we can conciliate them. So we have this specific scope on this principle due to our prioritization of time. We should see that there are different formulations of this principle in the convention on the non-navigational uses of international watercourses, which stresses the optimal and sustainable utilization, taking into consideration the interests of states, and it also mentions the protection of the watercourse, with the draft articles on the transboundary aquifers focus on the benefit sharing between the states and the maximization of these benefits in a long-term scenario. There are multiple uses that may concern an international watercourse or a transboundary aquifer, such as agriculture, industry. These two instruments present a series of uses that may be considered by the states in the allocation of water, but there is no hierarchy between these uses. So the uses are allocated considering the interests of the states, and there is no inherent priority between one use or the other. There is, however, one little specificity, which is the consideration of vital human needs in the allocation of water, considering the equitable utilization principle. In the Watercourses Convention, the wording states that in the event of conflict, that is, there must be a conflict between uses, there will be a special regard given to vital human needs. And in the case of the draft articles, there is a specific mention to a differentiated weight to the vital human needs. There are several implications to these wordings, and the main one is that there is a discussion whether this prioritization of vital human needs consists in a priority and a presumed priority of vital human needs over other uses, or whether it would only have a differentiated weight on the allocation of water. And even if we consider that there is a presumed priority for vital human needs, there are limitations to this priority, as it will only be presumed, as the general rule in the allocation of water, considering the equitable utilization principle, is that there is no hierarchy between these uses. And we should also stress that the vital human needs formula only protects a very restrictive scope of uses for vital human needs. It only protects well, at least in the form that they were conceived, water for the prevention of starvation and dehydration. So it will not be water for the an adequate standard of life, but rather it would be a form of protecting these uses that are essential for survival. So we see that there are some fragilities in this vital human needs formula, and there are some discussions if it even would be considered as customary international law, because the equitable utilization principle in relation to international water courses is considered to be part of customary international law, but the vital human needs formula did not achieve the same status. There is some practice in international law that could be employed to argue that it could be a part of customary international law, but it's still very controversial to state that there is a priority in customary international law for vital human needs over other uses in this allocation criteria. And that is where enters the human right to water. The human right to water was not initially established in the main human rights treaties, and not even on the Universal Declaration of Human Rights. That is because many scholars believe that at the time water scarcity was not a problem, and therefore it was not addressed. Some others state that it was as fundamental as air, and thus it was not necessary for it to receive a formal protection in human rights treaties or declarations. But we see that there is some implicit protection of this right in some general frameworks of human rights, and the main ones are the ICCPR, which protects civil and political rights, and the ICSCR, which protects economic, social, and cultural rights. And there were soft law instruments that interpret these treaties that state that the state has the obligation to comply with the human right to water, and they specificate the obligations contained within the right to water. And this general comment number 15, which was adopted in 2002, has become a very influential document for the consideration of the human right to water. So many soft law instruments and case law from universal and regional courts consider these instruments as reflecting a general formula for the human right to water. Of course, we also have some explicit recognition of the human right to water in conventions dedicated to the protection of specific groups, such as the rights of the child, of the prohibition of the discrimination against women, and also the rights of persons with disabilities. But even these explicit recognitions are limited to the protection of uses that are related to these specific groups. So we have a very fragmented framework for the human right to water, but it still provides some insight as to what is necessary to comply with an obligation related to this adequate standard of water for a dignified living. And some of these parameters to assess the obligations related to water are availability, quality, and accessibility. I think all of these three are somewhat related to the allocation of water. In the availability, we could consider the priority of allocation for the satisfaction of personal and domestic uses. Even the general comment number 15 stresses that there should be a priority for these uses in comparison with others that are related to agriculture, industry, and other competing uses in a watercourse or on aquifer. The quality parameter provides that there may be restrictions to some uses where there is also uses related to human consumption, because some uses may deteriorate the quality of the water resource and render it not adequate for human consumption. And lastly, there is accessibility, which is related to economic accessibility, a physical accessibility, that is to reach the water resource, and also the non-discrimination factor. So also this is very important for the allocation of water, because in the allocation and consideration of this several uses of a water resource, there must not be discrimination in the allocation of water. Given this general parameter, we can see that the human right to water provides several individual safeguards, even in a legal regime, in comparison with a legal regime that considers only the interests of states. So to give a brief parameter of some courts and some case law related to the issue, we have the Inter-American system that provides both negative and positive obligations related not only to the human right to water, but majorly the right to life in a spectrum of economic, social, and cultural rights, as to a right to an adequate standard of life. And in these cases related to water, the Inter-American Court stated that even in the case of positive obligations, the state may be obligated to comply with several parameters for the human rights to water. That is, if it had its authorities knew of the risk to the right to life, and if it could do something about it. So if we have a condition where the state knows of a situation where its population needs water, and it may allocate water to satisfy those needs, it would be under the state's obligation under the human right to water to comply with these obligations, even if its interests rely on other uses in an international watercourse. And I should mention that there are also case law in the Inter-American system related to other rights, but these two are the ones that focus the most on water allocation and its relation with environmental protection. And recently, the court has declared the human right to water as an autonomous right under its Article 26 that provides for the progressive development obligations. And it has also stated that it has a very intrinsic connection with the right to a healthy environment, even with climate change. So we have to consider not only the protection of the uses meant for personal and domestic uses, but also the protection of the environment, of the protection of water itself in the allocation of water and in the realization of the human right to water. And in the advisory opinion number 23 of 2017, we also have some very interesting insight on transboundary implications in human rights obligations. In this advisory opinion, the court stated that a state should not permit the activities conducted within its territory, within its jurisdiction, to impair the realization of human rights in other states. So we have both the obligation of the states to realize the human rights water in its jurisdiction, and also the obligation not to impair the transboundary, not to impair the realization of this right on other state, that is, not to cause a harm to these human rights in other states. So in this case, maybe an allocation of water could cause eventually transboundary implications that would inhibit the realization of the human rights water in other states, just as a preliminary insight of the conciliation of these legal regimes. We should also see that in the European system, we have some protection of the human and environmental health through the right to respect for private and family life. And even if there is no endangerment of these aspects, if there are direct and serious effects with intense and repeated consequences, there is a protection enshrined under the right to this right to respect for private and family life. And well, it's not case law, but the African system has, the Commission has established guidelines on the right to water in Africa. It's very similar to General Comment number 15, but it's interesting to note that even though it's the document that enhances the sovereignty of the states of this region, it also states that there is a need to consider a priority of human needs in water management. So with that in mind, we have these two legal regimes, one focused on this obligation of states, on the interests and rights of states, and other focused on the individual, the rights of the individual, and the development of an adequate standard of life. And they are very complementary, but they do not necessarily coexist in the same spaces. So there are some strategies that we may employ to conciliate them. And starting by the systemic interpretation, this approach is based on the consideration of other rules of international law, which is a method of interpretation enshrined in the Vienna Convention on the Law of Treaties. This specific item is also enshrined in customary international law, so it has a very intense impact on the relations between the parties. And in this case, I think it's important to stress that if a state is employing an allocation of water through an equitable and reasonable approach, it should not omit to consider the human right to water in this allocation of water, as even if it's applying the law of international aquifers or the law of transboundary aquifers, it is still bound to comply with the human right to water. So we have to have this systemic approach to international law, so the state does not sacrifice the human right to water in prioritizing other uses, and then violates international law in other legal regimes. This approach leads to the conclusion that it's unlikely that an allocation of water that would result in a violation of international law could be considered as equitable and reasonable. And this approach also enables the utilization of an evolutive interpretation of treaties if there are general terms relating to vital human needs or the allocation of water in general. So we may see an evolution of the law of international water courses that was codified in the 20th century, and the law of transboundary aquifers, as Imad said, has been adopted in 2008 before some major developments in the human rights of water, as the recognition by the United Nations and the Human Rights Committee. So we have these perspectives of some recent developments in the human rights of water influencing the utilization and application of the equal and reasonable utilization. And finally, where there is no applicable law in relation to transboundary aquifers, the human rights may be employed as a means to reach a protection of individuals. So even if you do not have a treaty or customary law stating that there must be considered an equal and reasonable utilization of the resource or the prioritization of vital human needs, the affected individuals may challenge the state through human rights courts to protect the human right to water. The problem with this approach is that there are several limitations of justiciability of environmental rights and social, cultural, economic, social, and cultural rights. So there are some limitations, and even the effects of the court may be hindered by the reluctance to apply standards of in the law of international water courses and the law of transboundary aquifers to these specific cases. So it might want to consider only the human right to water and not apply other instruments related to the cooperation, which may hinder the development of joint cooperation mechanisms between the states. Well, that was an overview of the issue of the transboundary aquifers and human rights water in this systemic and subsidiary approaches. And I remain available for our discussion and the questions that our audience may have. Thank you. So,
thank you, Amael, for this very interesting presentation and actually very insightful in terms of connecting transboundary aquifer or transboundary groundwater law with the human right to water and sanitation. Gabriel, before giving the floor to you, I actually wanted to ask you, as one of the leading experts in transboundary aquifer law, what's at stake here? Why do we really need to focus on the interplay between transboundary aquifer law and the human right to water and sanitation as lawyers and policymakers?
Thanks, Ahmad, and thank you, Amael, for that really fascinating presentation. I think this is a critical area, and I will start maybe, Ahmad, with your point here. The importance of this. Why bring these two topics together? We know that globally, water scarcity is really hitting hard many countries around the world, whether it's Middle East, North Africa, Central Asia. You have here, in my backyard, the U.S.-Mexico border. Precipitation is down. Population are growing, and there's a growing demand for water, and there's an imbalance between the available resources and the demand that it continues to expand. And so we're really facing a problem with water scarcity on a regional level, but also at a global level. And many people are looking to groundwater as a potential solution. You may have heard the term the silent revolution that Ramon Llamas coined some 20, 30 years ago. The idea that people are starting to use groundwater, but we're not paying attention. And they're doing so without getting permits because there's no legal regime in many of these countries. India, I think, is the example that Ramon always liked to exemplify. And it's true. The rate of extraction globally has just grown exponentially over the last 30, 40, 50 years. And we have become so reliant on groundwater resources today. Somewhere between 40 to 50% of the world's population relies on groundwater for their daily needs. Now, when you try to extrapolate that into a transboundary context, we don't have good data, in terms of which aquifers are they pumping from that are actually transboundary. But what we can do is we know that somewhere around close to 50% of the world's population resides in the basins, in the river basins that are transboundary. But we also know that these river basins have aquifers. They almost every single one has a transboundary aquifer connected to them. And so we can make the I think the logical leap. Maybe there's a presumption in there, but that most of these people are residing not only in a transboundary river basin, but in a transboundary groundwater basin. And so we know there's a huge dependence on groundwater around the world, and it's continuing to increase. So the idea of bringing the laws and policies and concepts of human rights to water together with the law of transboundary groundwater resources, I think is really important and really timely. And it is something that I think we definitely need further further research and further thinking about how do we really want to bring these two fields together. It's interesting that in terms of these two fields, they both seem to just have arisen from almost from nothing, but they've always been there. When we talk about groundwater, it's hidden. We don't see it, and we know we rely it. We pump on it, but we don't pay attention to it. We take it for granted that it's there and it's going to be there forever. Well, it's not. And so now we're starting to think about, well, how do we regulate it on a domestic level, but also on a transboundary level? But the human right to water is, I think, really similar in the sense that for decades, we took it for granted that it existed. It doesn't appear in the Universal Declaration on Human Rights. It doesn't appear on the two covenants. It appears only in 2 or 3 instruments. I think Amel highlighted the rights of the child. There's the CEDAW, Discrimination Against Women Convention, but that's really about it. And so we've just taken for granted the fact that, oh, it just exists. Well, the groundwater is there and we'll always have it. Human rights is there, to water is always there, we'll always have it. But it was never codified formally, except for the two human rights agreements. But still, just completely taken for granted. I think this is something that really needs to be to have a light, shining on it, because it is so critical and so important, and we need to stop taking it for granted. It has to be presented more formally. Now, for human right to water, I do think that we have more customary experience. By that, I mean state practice. We do have states that have implemented the human right to water within their domestic legal framework. We have seen it at the international level in the form of these resolutions and statements and so on. I think there's still a lot of space, a lot of opportunity to further strengthen the human right to water. So there is experience here in terms of state practice and customary law. In the case of transboundary groundwater resources, we have very little experience. We have been using groundwater for hundreds and thousands of years, probably in a transboundary context, but we've never formalized the relationship, the regime. And I think what Amel is trying to do here, to focus this human rights aspect to this relationship that we've never paid attention to is really important, because hopefully that will help develop the legal regime for transboundary aquifers, or at the very least, help implement a human rights perspective to this regime that we're now starting to see. At the moment, there's, I think, 7 formal agreements and 8 what I would call informal arrangements for transboundary aquifers, for specific aquifers around the world. But we've got more than 460 transboundary aquifers, and we're still counting. So it's a fraction, a very small fraction. So I think there's a lot of space to grow and to build this legal regime for transboundary groundwater, but we really do need to bring in the human rights aspect to it to help mold it. So just a couple of questions, maybe, Amel, to you, because I thought your presentation were really fascinating, and some things struck to me, and I think maybe we need to unpack or expand on the discussion here. So first of all, the human right to water is an individual right. People have that right. So you can say it's individuals or communities have that right, but as against their state. We don't usually think about it in terms of state versus state. It's really a person or community versus their government. Whereas the law of transboundary aquifers is between riparian nations. And so there's a little bit of sort of trying to think of the word, just it doesn't quite fit directly. And I'm wondering what your thoughts are in terms of how to make it fit better, this individualized legal regime versus this nation versus nation legal regime. Secondly, you brought up the human right to water, and then you also brought up vital human needs. that is present in the Transboundary Watercourses Convention. We see it in the draft articles. We see it in a few other places. And I wonder, I mean, is the vital human needs really the expression of a human right to water? Or is it just something different? And how do we bridge those two concepts? Thirdly, and there's 4 questions here I have. Thirdly, within the structure of equitable and reasonable utilization, which again is between states, how do we fit this individualized human right to water? And I think it's under equity, but I'm not quite sure how to do it when it's, again, going back to my first question, individual versus state to state. And then the last question, you've styled your presentation as the trying to get the implications of human right to water for the law of transboundary aquifers. But I wonder, what about the reverse? What are the implications of developing the law for transboundary aquifers, and what impact might it have on the evolution, the evolving human right to water? So let me stop there and pass the floor back to Imad and to Amael. Thank you.
Amael, you have a lot on your plate, so I will let you first answer all of these questions, and then we take further questions. So the floor is yours.
Okay, so very challenging questions. Thank you for this very intriguing discussion. I think it's a rather difficult issue, not only for transboundary aquifers, but for international law in general. How do we consider the individual in international law? And this has been a challenge that some scholars have been trying to tackle, and some even call it the humanization of international law, the consideration of individual rights of aspects pertaining to groups and people in an interstate relationship. And it is indeed a little bit difficult to conciliate the two, as they have very different perspectives. One is an individual requesting the compliance of his rights, and it's not an equal relationship. The individual is not in the same position as the state. Whether in the interstate relation, we do have this sovereign equality between the states. So I think the first method of conciliation would be to insert these considerations for other obligations in the calculus of the state. So the state, when applying the law of transboundary aquifers, even though it's not bound to consider individual aspects, the state's interests that are considered in the allocation of water, it should not deny the application of other rules pertaining to individuals. Because if the state does deny the application of these rules, it may be called to be, it may be held responsible within domestic courts and also human rights courts. And the Inter-American Court of Human Rights has demonstrated that it is open to apply parameters of environmental law to address the compliance of human rights. So we're reaching a situation that, even though there are some courts that are mainly focused on the demands of individuals against the state, we may soon face a situation where an interstate dispute is addressed in a human rights court. So we have these issues of fragmentation, but we also have instruments of cross-fertilization and the expansion of jurisdiction of courts that may be able to address the issue. But I think the best scenario would be for these obligations to be considered within the cooperation between the states and not in a judicial manner, which may be not optimal for the individuals or the state. And as to whether vital human needs are a human right to water, I think the formula of vital human needs was a very rudimentary human right to water, as at the time that it was adopted in the convention, the Watercourse Convention, there was no development, any significant development in the realm of human rights. But there are some authors that argue that it is a representation of human rights in the law of international watercourses. It's not the same thing. There are very similar implications, but that exist independently in two legal regimes. But nevertheless, we can use the developments that occurred in the law of in the human right to water in the last 20 years to state that there may be an evolutive interpretation of the vital human needs. So at the time they were conceived, they only encompassed the water necessary for survival. But recently we had developments that that's not sufficient for an adequate standard of living. So we may expand vital human needs considering the establishment of human rights and specifically the parameters for the satisfaction of the human rights water in international law. So they are different, they are separate, but they coexist in a very inter-exchangeable manner. As to the implications of the law of transboundary aquifers for the human rights water, actually, I think that there may be very significant contributions as the human rights water does not adequately protect the environment in itself. It protects the environment only to the extent that it's necessary for human health or the satisfaction of human rights, but it does not consider the environmental protection aspect of this relation. So we have a fragmentation. On one side, we have the protection of individuals, of groups, and on the other side, we have the protection of the environment, even if in a kind of limited way, focus on the sovereignty of the state. But we do have some possibilities of interexchanging these instruments to enable environmental protection within the legal regime of the human right to water, and also the consideration of individual rights, individual interests in the allocation of water in the law of transboundary aquifers. So there are mutual contributions between the legal regimes, and I think, as you said, those are under development. We also had very recent developments in the two legal regimes. It's not well, a closed debate, but I think that if we manage to bring the two together, even if slightly, we may be able to have very significant contributions to both regimes.
Thank you very much, Amael, for this response. Gabriel, do you have anything to follow up on what he said, or do you open up for the questions from the audience?
I think we should go ahead and open up the questions. I think there's a lot to discuss here, but I think having the audience handle those questions in the Q&A.
The first thing is that we agree with Dr. Joseph that we need to point out that the draft articles in the Law of Transboundary Aquifers is still a draft articles. It's not a treaty, hence it doesn't have the same status as the UN Watercourse Convention. There is a very interesting question made concerning the relation between states or governments, the private sector. How do they both fit in this conversation? The private sector, in terms of water companies, are trying to seek profits. Governments have to provide water. All that is happening in transboundary context. How does this fit in this debate taking place? That's one of the questions made. So maybe a second question would be as well, are there examples of transboundary aquifer treaties that are actually working despite their rarity? So I think I would ask this question to Gabriel and the first question to Amael to be able to respond. So I would start with Gabriel because it's a more general question. As you mentioned earlier, transboundary aquifer treaties are rare and they're very few despite the importance of transboundary aquifers and the huge number. So are there actual examples of transboundary aquifer treaties that are efficient so far? And if you want to combine that with where would the right to water fit there? Yes.
So I mean, there are examples of agreements over transboundary aquifers that are working, but you have to also frame it in terms of, well, what are they working for? What's their purpose? So, for example, the one that everybody points to is the Genovese Aquifer Agreement. It's been working for 50 years now, and now 40 or 50 years, and but it's a very technical agreement. It doesn't necessarily provide legal rights to any, to one country or another. It really creates obligations in terms of monitoring artificial injection of water for recharge, maintenance, covering fees, and so on. And the two parties, the province of Haute-Savoie in France and the canton of Geneva in Switzerland. It's a cooperation that is, I think, quite unique because it actually leaves the legal stuff out. It doesn't deal with rights and rights in the traditional sense. Now, does it incorporate human right to water? Not directly. But I think in terms of ensuring that water is available for the populations, I think it does it indirectly. So it's not in the treaty, but it does provide it indirectly. Then let's compare with the DC aquifer between Jordan and Saudi Arabia. This is an agreement to not to pump, basically, and not to pollute. It's not an allocation. Again, it doesn't provide rights in the sense of, one country gets X and another country gets Y. It's an agreement to protect the aquifer, and it seems to be working very well. So we have different examples of aquifer agreements around the world, but they have different purposes. Just a few other examples: the Guarani Aquifer Agreement in South America. It's a framework agreement. It has legal principles, but very little details. And then in your part of the world, Imad, the Nubian sandstone, you have a series of instruments that, individually, I'm not sure that they as an individual practice, one is a treaty or such, but together, I think they actually do form a treaty regime that really addresses a lot of data sharing issues and cooperation and monitoring, not allocation. So again, there's some interesting differences in terms of what success could mean in different parts of the world, but there are some very good examples.
Interesting. That's a long conversation, obviously, to have over this topic. So I will come back to Amayel concerning the question was asked. So we're discussing transboundary aquifers and the human right to water. Not every state has the capacity or the willingness to extract groundwater. They leave it to the private sector. So if you bring in another element to this conversation, how does that fit? How would having the private sector involved impact the implication or the application of the right to water in a transboundary aquifer context?
I think that there are two main implications. The first one is that the state is responsible for all activities that occur in its jurisdiction. So we have these due diligence parameters in international law, such as the Corfu Channel case, and also several cases in international law that address the activities conducted within a state. It may be the state itself or the private sector working under the auspices of the state. And this also enters a very difficult area of lack of regulation that Gabriel mentioned. It's not only on the international sphere that we have several limitations in relation to the utilization of aquifers. And as you said, the technology and the capacity to operate these water resources is significantly more complicated than the utilization of surface waters. So I think the first one would be that even if the state delegates the responsibility to the private sector, it is still responsible to keep that company in check, and it may be held responsible if there is some kind of transboundary harm or misuse of these concessions to utilize the water resource. And there are also implications for international investments in the states that have these legal regimes applicable for the investments. We had a case in Argentina that, well, not related to aquifers, but related to the operation of water and sanitation facilities, that the company was held responsible for the compliance with the human rights water in a sense of public order in the investment. So even private companies are not immune from understanding and applying the human rights water, be it on the application of a water facility or by extracting groundwater. It's all related in one public service that reaches the population. So, and that it's interesting to see that we have, for instance, in Latin America, the Guarani aquifer that has a very significant impact for the water supply in some regions in Brazil and other countries. And it reflects to some extent, I mean, effectively, significantly, the draft articles on the Law of Transboundary Aquifers. It's a very similar instrument and illustrates how, even though we may not be able to speak of a customary law of transboundary aquifers, we see that the draft law of transboundary aquifers are influencing the drafting of treaties and the application of this law in several legal, regional and local regimes. We may even use that to assess how would be the relation between different units of federations. For instance, in Brazil, we have disputes between states, the units in our federation for the utilization of aquifers. So even to that extent, we see that there are conflicts, but in all of these instances, we may be able to employ the human rights water and to connect these legal regimes, be it public or private, I think.
Thank you very much for this. I actually have a couple of questions, one for each speaker. Gabriel, first to you. We see in certain like water charter treaties, such as the Senegal Charter treaties in Africa, they already include a provision concerning the right to water. This is with regard to surface water. Is this a model to follow for the future when it comes to transboundary aquifers? And what would likely be the implications of doing so? So that's the first question. The second question to Amael, the scope of the human right to water is much bigger than the term or the concept of vital human needs. So would this be an indication to move forward with ditching the term of vital human needs towards in favor of the human right to water and sanitation within international water law? Would this be potentially a possibility? So yeah, I will let the speakers answer the questions. Gabriel first.
All right, thank you for that, Imad. So in terms of having a human right to water within a water course treaty, that's your question, right? You mentioned the Senegal agreement. My concern is that when you have a watercourse treaty, typically, now this could change in the future, but typically the focus is on water management, water allocation. And when you bring in things like groundwater, human right to water, or all these other topics, they typically get a secondary position and secondary priority in these agreements. And so my initial reaction is to say, no, that's not good enough. So we need a separate treaty. But the problem is when we have too many separate treaties, as I always talk about fragmentation, it's really difficult to, put all these things together and then trying to figure out where do they overlap, where do they conflict? And then we have all sorts of challenges in terms of integrating all these different sources of law. Ideally, in the best world, it would all be the law of water, right? And it wouldn't be transboundary or domestic or groundwater or surface water or human right to water or water for the environment or anything. It'll be in one comprehensive agreement, but I think we're still far away from that. So for now, I think I have to say that if there's a way to bring in, to prioritize a human right to water inside those treaties and not make it a secondary issue, yes, I think that should be done, and it can be done. But if not, then I do think the human right to water is still, in my mind, in a fragile state of development, because it was so ignored in the past, and because there's still no global treaty on the universal human right to water. We find it the rights of the child, we find the rights of women and discrimination, but not as a global matter. And so I think until we get to that point, we're still in sort of a fragile state and vulnerable state in terms of, does it exist? Does it exist everywhere? Does it exist for everybody equally? And so on.
Let me just follow up on this question, because it's a very interesting question related to that, whether the status of the Water Convention, in addition, if you combine that with the model provisions on transboundary groundwaters, would provide a solution, considering that there is also a protocol on water and health. So would this regime be rather more holistic to cover also the human right to water without the need to include the human right to water in it, or that's not sufficient?
No, I think you have to be explicit in today's world. If you're not explicit, it's ignored. I think it, and you mentioned the model provisions for the UNECE Water Convention. They're model provisions or guidelines. I think they're getting even less attention than the draft articles. They should get more attention, and they should be debated further, but because they're not prioritized, I don't think that they're given the respect that they should have.
Right. Amaya?
I think that one of the biggest difficulties relating to let's say the elimination of vital human needs in favor of a human right to water is the different perspectives, not only material law applicable, but also the relations between the states, as Professor Gabriel has pointed in his question, because the law of international aquifers and transboundary international watercourses and transboundary aquifers focuses on interstate relations. So even if we put a human rights water there and a state violates the human rights water, only the other state would be legitimate to allegate the violation of human rights. There is no individual in this relationship. So we may be able to confer some consideration for the human right to water, but the relation of the individual with the state remains the individual and his respective state, or and to some extent the responsibilization of other state by the human rights courts or domestic human rights decisions. But there is some limitation to the participation of the individual in international law. The individual cannot go to the International Court of Justice and cannot require an application of the principle of equitable utilization in accordance with the human right to water. It can only plead the human right to water as it stands today. But I agree with Professor Gabriel that we should try to give a more wholesome view of these legal regimes. And as they stand today, they are separate and do not offer adequate legal protection. They do not enable individuals to have a say in the allocation of water. So it has to wait for their rights to be violated in order to take action. This is very limited. So we should work for the conciliation of these legal regimes, but I think as they may not be on the interest of the states today, as it stands today, to eliminate a vital human needs formula, which is more adherent to the interests of states and their objectives, because they may sacrifice human rights if they wish to do so. It's their sovereignty over natural resources, and well, but that is a challenge that we may work to to address and to enhance the legal force of the human right to water.
I'm gonna stop you here, but there are so many questions. So I have, for instance, this very important statement that I would like both of you to try to comment on. The human right to water has to be a contract between the citizen and his government. In a transboundary context, it's a state-to-state relation, so the human right issue seems to be quite difficult and perhaps dissipating the issue that transboundary resources management demand. So it seems that there is, or at least some of the attendees are highlighting extreme complexity of actually addressing this topic in a transboundary context. So perhaps the question that this demands is the following: can we actually do that? Can we actually connect and create synergies between in the transboundary context? At the state level, it's easy. A state can take a decision. We include the human right to water and sanitation within the constitution. Then we take into consideration our groundwater law. It's easier than in transboundary context where different factors play a role. So perhaps the question is it feasible? We're discussing a topic where we now create synergies, but in practice, can we do that? So that's the question first I address to Gabriel and then to Amael.
Well, first of all, I should say thank you to Shami for that question. It's good to read you here. It is possible. I think it is possible, but I think you have to have the conditions that make it possible, and the conditions are very complicated. You have to have regimes that are willing to consider human rights. For example, if you have a regime that doesn't respect human rights, you're never going to get to a human right to water. Human right to water typically becomes secondary or tertiary if you don't have the right to association and right to participation in speech and so on. So it sounds fundamental. You need water for life. But you have to advocate and be able to advocate for those rights, for a right to water. And if you don't have the right to advocate, then you're not going to have the right to water. So you need those kind of conditions in the countries to have the framework or the foundation. But it's been done. It's been done in places, in Southern Africa, clearly in Europe, North America, parts of Latin America, and other places around the world. It has been done. But you do have to have the right foundations that facilitate the connection between the domestic obligation of providing human rights and to make that connection. Well, it's coming from a transboundary aquifer, and therefore we have to have that transboundary relationship with the other country. There's been a number of people who have written about the transboundary obligations of the human right to water, which I think is really pushing the envelope in terms of, can we actually make a human right to water cross-border? I think that stretches international law, but I think that's a good thing. I think we do need to stretch international law to question these things and say, is there a way to do it? Should we do it? Maybe the answer is no. But by pushing these questions forward and trying to see if there's a way to make them, to create obligations at that international level, could it expand the domestic obligations and respect for things like the human right to water?
I'm going to follow up with a very interesting question also made. Do we need to make a difference between fossil aquifers and non-fossil aquifers in this regard when you discuss the human right to water and sanitation? So Gabriel first, and then I will pose both questions to Amael so directly, but first, because the question was here is very interesting, so we can follow up on this.
So water is different. It's not like oil and gas. It's not like forest. It's not like fish. It's one of only two. It's not a substance. It's two things in the world that we absolutely need. We need air and we need water, and there's no substitute. That's the problem with water. There's no substitute. We have substitutes for wood, for forest. We have substitutes for energy. we do not have substitutes for air and water. So whether it comes from a non-recharging fossil aquifer or from a recharging renewable aquifer, I think the basic foundation of the importance of water has to be equal, regardless of the source. Now, how you manage it, I think you have to start thinking about terms like sustainability. Well, if you just define sustainability as maintaining that resource into future generations forever, then you can't do it with fossil aquifers. That means you must never use that aquifer. But you can define sustainability in terms of sustainable depletion. I know that sounds awkward, sounds kind of strange, but you have a time horizon. We want 50% of the aquifer to be available in 100 years. So you have some kind of managed depletion. Hopefully in that time frame of 50, 100, 200 years, you find other resources to replace that depletion. But you guys have to realize a fossil aquifer, you start pumping, it's gone. So how you define things like sustainability and equity in a fossil aquifer may be different from a recharging aquifer. But the basic notions of water for human rights, water for the environment, and so on, I think that those foundations are the same.
Thank you very much for this. Amaya, there is an interesting question for you because you addressed that in the presentation concerning sovereignty. How do we, states are very big on the question of sovereignty. Sovereignty over natural resources, it's our resources. When you put this in the context of human right to water and transboundary groundwater, how does sovereignty fits here? If at all it fits, I don't know.
Well, that is a very challenging topic because the human right to water is an economic, social, and cultural right. So to an extent, we have positive obligations related to this right. It's not only the state omitting itself from violating a personal aspect of a human right, but it's related to the connection of the individual to the facilities that the individual may be able to access water. So there's money involved, there are investments involved. So it's a very complicated thing to state that the human right to water would be without borders, would be not restrictive to the state's jurisdiction. But we also cannot state that it does not have transboundary consequences, because if a state, if the actions of a state cause other state not to be able to realize the human right to water in its jurisdiction, so we have a transboundary effect that violates human rights. It's not necessarily the state affected that is not complying with the human right to water, but it's not complying because other state committed an internationally wrongful act. So an international court would be able to address the issue to eliminate the responsibility of the state that is not complying with the obligation and attribute this responsibility to the state that caused the harm in the first place. So there could be implications for this transboundary violation of human rights, but there is no transboundary realization of human rights. It's very difficult to say that, for instance, Brazil would have to invest in Paraguay to make the right to water universal. But Brazil cannot cause a pollution in a way that would hinder the realization of the human right to water in Paraguay, for instance. So we have these different repercussions that exist in the human right to water, and they may be connected with the allocation of water, because, for instance, a state may illegally divert a river, and it will not pass in the other country, or a river that was used for human consumption. So we have several discussions as to whether this allocation of water could constitute a violation to the human right to water in a transboundary context. And as for fossil and non-fossil aquifers, I agree with Gabriel that the key term here is sustainability. How we conceive, how we understand sustainability dictates how we're gonna deal with aquifers, both fossil and non-fossil aquifers. And I think that in the case of fossil aquifers, it's very important to consider alternative sources in this light of future generations. But I think that we surpassed the vision that we're only supposed to protect the resource. We're also supposed to share the benefits that that may be extracted from this resource. And in this case, we have a sort of disparity between human needs and environmental protection. So we have to conciliate also this tension in order to be able to reach a solution for this problem. And even in recharging aquifers, in the case where water would be used in a pace in a faster pace than the recharging of the aquifer. These are very difficult questions and that do not have a pre-established answer. It depends on each specific case and how it's being addressed by the states, consensually or judicially. So
thank you.
Very interesting topic.
Gabriel, there is a question that goes behind even more than discussing transboundary aquifers, more concerning transboundary water resources. There, the audience is really bringing very complex issues to the table here. So, and I'm going to give the example of what happened during ISIS, where it was in Syria, and they tried to stop the dam, or they tried to blow the dam in Mosul in Iraq. So that's, and that the dam and the river is a transboundary river. So when you try to bring this topic, whether transboundary surface or groundwater, into a situation of conflict, is there anything can be done there? We have a conflict. It's going on. Both parties want to get rid of each other. Why would they even think about bringing a human right to water into that lens, and whether it's even possible?
Whether it's possible is I think the problem. Look, you have a series of you have a humanitarian legal regime in place in terms of the laws of war and what states are supposed to abide by in terms of, you know, not attacking water installations and civilians and civilian targets and so on. And there's a series of Hague Conventions and other treaties on, you know, the law of war. I've always found it very strange that you create law for how to conduct war when the whole point of war is supposed to be to conquer the enemy. But yeah, we've created laws for war, and in some cases, you know, countries do follow them. I think there's the situation right now between you know, the Russia and Ukraine in this conflict, in this war. You know, you have Russian aggression against water resources in Ukraine, and that is a violation of international humanitarian law. How do you bring human right to water in that kind of a context? Now, ideally, theoretically, at least, human right to water should be at the foundation. It should be at the base of everything we do. And then everything beyond it should sort of always default, well, if everything breaks down, we have human rights. That's the ideal. It doesn't always work the same. You know, work in that way. When you look at how wars are conducted, you know, there's all sorts of atrocities and human rights violations. Ideally, theoretically, yes, human right to water should be at the foundation of everything. Whether it's the war between Russia and Ukraine, or a conflict. Right now, we've got conflict in Sudan. We've got conflicts in other parts of the world. That we'd like to have that ideal there. I'm not sure that we as a species have quite risen to that ideal quite yet.
Unfortunately, I have to agree with you on this. War is always tragic, and we cannot do anything about that, even if we try to do something. The final question I would ask Amael, and then I'll ask Gabriel also the final question. There's a very basic question here which we did not address. So the audience is asking, well, you want to apply the human right to water in the transboundary context. What does that entail? Is water sufficient for drinking? Are we talking water for agricultural production, for energy? How much water is enough to say the human right was satisfied or is satisfied? So, Amayel?
Well, in terms of the existing instruments of human rights, the core obligation that could not be derogated by the states would be personal and domestic uses. And that would be a very restrictive vision that would amount to nearly 20 liters of water a day for the personal use of each individual. So as that connects with the question that Gabriel asked as to whether it's individual or a group right, and it's both, but the parameter for availability that we have is focused on the individual. But there may be cases where we have a collective need to satisfy this right, which would be the installations for the provision of water. So we do not, in our society that is complex and involves cities and such, the individual does not only go to the water. Well, it may be the case in certain circumstances, but the universalization of the human right to water is related to investments in water and sanitation facilities. So there may be also these peculiarities, but in a simple answer, it would be only the necessary for an adequate standard of living, for cooking, for washing clothes, for taking a bath, and for drinking water. It's a very restrictive scope that is we may be able to expand it in the future as our visions on what is an adequate standard of life progress. But as it stands today, is still very limited, even though it's sufficient to guarantee these minimum standards.
Interesting. Gabriel, there is a question here which goes as follows. I'm trying to interpret what the attendee has wrote. What exactly is the international community doing when it comes to pushing forward the agenda concerning transboundary aquifers and the human right to water and sanitation? And they were asking questions whether UN conferences are taking place. I would say there is the UNESCO conference every year on transboundary groundwater taking place. Next year as well, they're doing that. But mainly the question is, what is the international community doing in this regard?
Well, maybe I'm biased on this, but I don't think they're doing enough. You mentioned a UN conference on transboundary groundwater. That's actually only happened once every 10 years. It happened in 2010 and actually then last year, so 11 years. And it would be great for it to happen more frequently, but I don't think that countries are quite ready to prioritize the importance of transboundary groundwater resources quite yet. I think they are still learning. It's really hard to explain to a policymaker what an aquifer is. I mean, you can throw the word groundwater, you can throw the word aquifer around, but they can't see it in their mind. They don't understand it, and so there's an educational threshold that we're struggling with, and so I think this is evident in at the national levels and also at the international level, at the UN level, to try to convince these diplomats and policymakers that groundwater is important. They will say, "Oh yeah, water is important." No, groundwater is important. Well, what does that mean? Well, groundwater is water. They don't quite understand the differences, the nuances between surface water flows and groundwater flows, and dependence on surface water versus dependence on groundwater, and the way you manage the two regimes. And yes, they're all integrated. And as I said earlier, we need a more holistic approach for everything. But I don't think there's enough attention. We do have occasional conferences and programs. UNESCO has been particularly active in this. The International Hydrological Program, they produced manuals, training manuals and reports. And I will say one more thing. They're now with SDG 6, There is a reporting requirement on transboundary waters generally, and specifically on surface water and groundwater. So now we're starting to see information starting to come in, and states are being asked to report on, do they have any kind of agreements, treaties, informal arrangements with their neighbors on groundwater, on shared groundwater. And all of a sudden the states are asking, oh, what does this mean? So we're starting to educate and to teach and get them focused on this, but there's a lot more that needs to be done.
All right, I'm going to ask the final two questions this time. One for Amael, one for Gabriel. So Amael, we're discussing the human right to water in the context of transboundary aquifers. So if you try to bring this back to the entire conversation concerning international water law, how would you connect that with surface water? Plenty of things have been done on this topic in terms of connecting the human right to water with surface water, less on groundwater. So perhaps, why do you think it's less on groundwater, and how can these two be connected in this context? So I'll start with you.
I think that there are more works focusing on surface water because it receives more attention both in international and domestic law. And as we have a more established customary international law related to water courses, I think it's easier to interpret what could a human right to water entail for this specific obligation. In relation to transboundary aquifers, as Gabriel mentioned, we still are in a stage of development of these rules. Even in these legal regional frameworks, there isn't much practice related to human rights and water in relation to groundwater specifically. But we do have a very significant amount of practice pertaining to human rights water or the prioritization of vital human needs in relation to surface water. So these legal regimes are very similar, but this difference in scope, this difference in treatment in relation to sovereignty leads to a more established regime in surface water. So I think it's a work both of developing the transboundary water law regime, groundwater law regime, and also developing the human right to water and the practice of this right in relation to groundwater, both in domestic and international spheres.
Thank you, Amael. Gabriel, the question is larger. Today we have discussed the connection between transboundary aquifers and the human right to water and sanitation. In other cases, we were discussing water, energy, food nexus, climate, water, energy, food nexus. These are not two, although they're sort of separate conversations, but they're essentially connected. So if we open this Pandora box where we connect the human right to water with one natural resource, which is water, what would you think would be the implication for the nexus in general, and for the connecting this with other natural resources? And what would that even imply to international human rights law, where you have different sectors being regulated by different fields? We have the right to water. We're in the process to discussing potentially the adoption of right to energy. We have the right to food. So we're essentially opening up, we're all paving the road towards this discussion taking place. So what do you think of that? And what would you think the long-term implication?
Look, the whole notions of human rights has been a constantly evolving ideal or sets of ideals that when we started off a few hundred years ago as feudal communities, trying to protect tribes. Really weren't considering things like human rights and individual rights. So this is something that has evolved over decades and centuries, really. And this is something that we are starting to think about, what are we as human beings? What kind of species, what kind of a species are we? And do we differentiate ourselves from other species? Dogs, cats, monkeys, birds, and so on. And we seem to think, I'm not sure we're right, but we seem to think that we're different from those other species and that we should deserve some level of special protection. And that special protection has been in this evolving concept of human rights at the individual level and at the community level. I don't think we're anywhere near done. So you mentioned, okay, we've been talking about the human right to water. You mentioned human right to energy. And I'm sure that, we've already talked in decades past about right to shelter, right to food. These are concepts that we didn't think about 50 or 100 years ago. And we're going to continue to evolve and build on these notions of what kind of rights, because we are human beings, are we entitled to. But we're doing this piecemeal, fragmentation of the law. And then we're bringing up all these, all this, as you said, the nexus. Again, I'm biased. I do think water is at the center. And I do think that it should be considered at the center of most things that relate to life. But we're doing this in a fragmentary way because it's very hard to conceptualize everything. How do we have a comprehensive series of rights for everything? We're always looking for the universal answer to everything. I'm not sure it exists. There's multiple answers, and we are going to have to work piecemeal and then slowly figure out how do they fit. How does the human right to water fit into the law of transboundary groundwater, the law of transboundary aquifers? We're going to have to figure out how this fits together. It's going to take time, and we're going to make mistakes. But we, as a species, we've evolved and we continue to evolve. And I think this is the natural, some of the natural progression that we're going through. And hopefully we will continue to make progress, and it'll be positive progress. But so I'm a bit optimistic about that. But yeah.
Thanks a lot for this last note. I would just like to thank all the attendees, and I would like to thank the speakers for the insightful first presentation and for the exchange and the questions from the attendees as well. Lindsay, back to you. Again.
Thanks, Ahmad, and thank you both to our speakers, Amel and Gabriel, for this very enlightening conversation. I was following the questions, and it was very lively discussion, and I think some of them put some really great questions that I hope we can tackle maybe later for them as well. Thank you to the audience for interacting in the dialogue, in the chat, in the questions. We always hope to address all your questions there. And would like to invite you, we always post the recording of the webinar on our website. So in about a week's time, we'll have a summary of the session posted as well as a video recording. You can find that on iwra.org/webinars. Also, please follow us on LinkedIn. We have lots of events coming up that we post regularly. I just posted a few announcements in the chats with links for you to follow. One of them is the early bird registration for the upcoming World Water Congress will now be open until May 7th. You can register on the link provided in the chat. Another announcement is we have a master class that will be taking place also in May. You can find more information on the link provided. The title of the series is called Institutional Responsibility in the Support of SDG 6 and the Rights to Water and Sanitation. I believe that you do need to be a member to join. There are links to join the public presentations. So click that link, look for more information. And as always, if you're interested in joining IWRA as a member, please feel free to contact one of us, as well as you can register on our website. And the last announcements is that we have a call for papers, lots of announcements here, for the global water security issue number 6, which focuses on biodiversity protection and water security, is now open, and the deadline is on the 12th. You can click the link. Thank you again for joining us. Again, a big thank you to our speakers and moderator for making your time and sharing your expertise on the topic. And on behalf of IWRA, thank you all for viewing this webinar.
Thank you. Bye-bye.
Bye.